Assalamualaikum and hi. My name is Nurul BALQIS HIDAYAH binti Muhammad SUHAIMI, matric number 065469. Today I would like to introduce you to the Malaysian court system. The Malaysian court system can be divided into two, which is subordinate court and the superior court. The hierarchy of courts of Malaysia starts with the magistrate court as the first level, followed by session court, high court, Court of Appeal and the Federal Court. Magistrate Court and Session Court is the subordinate court, or also known as lower court, and High Court, Court of Appeal and Federal Court is the superior court, or we call it the higher court. Today, we will be discussing more about Magistrate Court. The Magistrate Court was established under Section 76 of Subordinate Courts Act 1948. Under Section 76, a Magistrate Court shall have jurisdiction to hear and determine any civil or criminal cause or matter arising within the local limits of jurisdiction assigned to it under this section. This means that it gives power to the Magistrate Court to hear any civil and criminal cases within its limit of jurisdiction. There are two types of magistrate, a first-class magistrate and second-class magistrate. The Magistrate Court is presided by first-class and second-class magistrate. First-class magistrate for the Federal Territory is appointed by Yang di-Pertuan Agong on the recommendation of the Chief Judge, while in the state, a first-class magistrate is appointed by the state authority on the recommendation of the respective chief judges. First-class magistrate must be legally qualified and members of the judicial and legal service. This is provided under Section 78 of the Subordinate Courts Act 1948. Second-class magistrate for the Federal Territory is appointed by the Yang di-Pertuan Agong, and the state authority may appoint any fit and proper person to be a second-class magistrate for the state. Second-class magistrate does not need to be legally qualified. This is provided under Section 79 of the Subordinate Court Act 1948. As we know, Magistrate Court and Session Court is the subordinate court. But what is the difference between these two courts? Magistrate Court is presided by first-class and second-class magistrate, while the Session Court is presided by a Session Court judge. A Session Court judge is appointed by the Yang di-Pertuan Agong on the recommendation of the respective chief judges. In terms of jurisdiction, the jurisdiction of Session Court of Malaysia is wider than the Magistrate Court. The Magistrate Court has the power to hear any civil and criminal cases. In civil cases, Magistrate Court can hear any cases with the total amount of dispute or claims less than RM100,000. In criminal cases, Magistrate Court can hear cases with fine and imprisonment not exceeding 10 years. Or fine and may sentence not exceeding 5 years of imprisonment. Fine not exceeding RM10,000 and or 12 times of whipping. The Session Court has higher power in jurisdiction. It can hear any civil cases with value more than RM100,000 but not exceeding RM1 million, and all criminal cases except for the case subject to death penalty. If your claim exceeds the Magistrate Court's jurisdiction, then you have to sue your opponent in the Session Court. The same idea applies if your claim exceeds the Session Court's jurisdiction. You then have to sue in the High Court.
Assalamualaikum warahmatullahi wabarakatuh. My name is Nurul Aqillah binti Mahadi. My matric number is 067680. Jurisdiction means the right to decide. In relation to courts, it refers to the type of cases that may be tried where it cannot exercise its power in matters over which it has no jurisdiction. On the other hand, in dealing with matters over which it has jurisdiction, it cannot exceed its power. Thus, a court may be described as exercising civil or criminal jurisdiction. Magistrate court has only original jurisdiction because of the abolishment of penghulu court. Original jurisdiction is power of the court to hear case for the first time, i.e. court of first instance. The first-class magistrate court are divided by two, which is civil jurisdiction and criminal jurisdiction. For the civil jurisdiction, the first-class magistrate court has the jurisdiction to try all action and suit of a civil nature where the amount of dispute or value of the subject matter does not exceed 100,000 ringgit Malaysia. If it is more than 100,000 ringgit Malaysia, the first-class magistrate court does not have the jurisdiction to hear such cases. Therefore, those cases must be tried at the session court. However, he may try cases exceeding such amount if only both parties agree in writing. Next, for the criminal jurisdiction, the first-class magistrate court has the jurisdiction to hear the criminal offences which the max term of the punishment does not exceed 10 years imprisonment or any type of criminal offence which are punishable with fine only. For example, in kidnapping offence where the punishment is 7 years imprisonment. Moreover, first-class magistrate also to try offences under Section 392 of the Penal Code, which is for robbery offence, and Section 457 of the Penal Code for the offence of lurking or house trespass or housebreaking at night. Nevertheless, the first-class magistrate only has power to pass sentence up to 5-year imprisonment or a fine up to 110,000 ringgit or whipping up to 12 strokes or maybe the combination of any of the offence said earlier.
Hi, my name is HAZWANI binti ZAINOL. My metric number is 067699. For the second class magistrate, according to Section 79 of the Subordinate Courts Act 1948, Act 92 provides that the state authority may appoint any fit and proper person to be a second class magistrate, or in Malay we call Magistrate Kelas Kedua, in and for the state. Meanwhile, for the Federal Territory, a second-class magistrate is appointed by the Yang di-Pertuan Agong. Jurisdiction for the second-class magistrate. In civil jurisdiction, it may hear a civil case when the amount claimed by the plaintiff in dispute not exceeding 10,000 ringgit Malaysia. If the amount claimed by the plaintiff is less than 5,000 ringgit, the plaintiff can claim through the small claim proceeding. As for the criminal jurisdiction, it may hear a criminal case whereby the offence is not exceeding 12 months or a year imprisonment or fine. If the judge believes that the accused should get a penalty that is beyond his powers, there will be another trial with the first-class magistrate. A second-class magistrate may impose punishment in imprisonment less than 6 months or fine not more than 1,000 ringgit Malaysia or any combination of the punishment above.
Assalamualaikum and hi. My name is MAHFUZAH Aqillah binti Muhammad AZHARI and I is ASWANDEE and my matrix number is 066911. Quick, simple and cheap. 3 words that will come out in mind if the topic of the discussion is about the small claims. So what is the history of the small claims? On 1973, the Small Claims Court was introduced in England, and according to Lord Wolff 1996, the Small Claims Court was introduced because the government has worries about the ability of the consumers to obtain access to justice due to high cost of trial. In of Small Claims Court (SCC) was held at the Conference of Magistrates of Commonwealth Countries at Kuala Lumpur in 1975. The first trial and proceedings of small claim cases was on 2nd January 1987. There is no lawyer that will represent both the plaintiff and the defendant during the trial. Thus, the plaintiff don't need to spend money to hire any advocate to represent him or her. The plaintiff only needs to pay the filing fees, which is only 10 ringgit. The procedure of the small claims was provided in the Order 9.3 of the Rules of Court ROC 2012, which is provided to be a guidance for the plaintiff. The first step in the procedure is the plaintiff must fill the Form 198 with the particular of the claim, like why the plaintiff wants to claim against the defendant, or what kind of breach did by the defendant, or how much the plaintiff wants to claim against the defendant. And there must be 4 copies of Form 198. Next, extract the sealed copies of Form 198 and give it to the defendant. Lastly, within 14 days from the date that the defendant gets the Form 198 from the plaintiff, the defendant can make a defense by filling the Form 199. Also, there must be 4 copies with the registry from the magistrates. And if the defendant wants to make a defense, the plaintiff have to fill the Form 200. That's all from us.